Wasima, do we have Zaakir?
Zaakir is not on the line yet. I think we could start, Ilse, at 7:30 on the dot.
Excellent. Good morning, everybody. Thank you for joining us at this, our very first webinar on eDiscovery in South Africa. We also decided to do it on International eDiscovery Day, which we hope to be continuing celebrating as we expand on eDiscovery in South Africa. As you could have seen from the invitation, we realize that South Africa is a long way behind on other jurisdictions to embrace eDiscovery. And there's a long way to go with the rules of civil procedure. And we need to have a look at why is it needed, why is changing the rules needed, or if indeed it is needed. And are you, as a user of electronically sourced information, satisfied or comfortable that you have found every relevant document and that it's been correctly collected? So without much further ado, I'd like to introduce our panel. Firstly, the moderator for our webinar and panel discussion will be Wasima Harrison. Wasima is the
Head of Litigation
Support Services at Lestrado, and one of the more experienced, or most experienced, eDiscovery specialists in the country. She has extensive experience internationally in eDiscovery, and in 2014 decided to come and practice her trade here in South Africa. And we're fortunate to say that she's now with Lestrado. May I also mention that she's probably the most certified in eDiscovery software of most people I'm aware of in South Africa. Please have a look at the different profiles online and the links that has been put in there to hear a little bit more about our different panelists. Advocate Ismail Hussain, Senior Counsel, welcome, sir.
Thank you.
This is a former judge of the Competition Appeal Court and a judge of the High Court. And at present, he is training with LEAD, which is one of the trainers of our legal profession here in South Africa. One of the aspects that he is of great interest is practice management, legal drafting, and technology, which is growing and so important in our day-to-day lives during litigation these days. Then Terry Harrison. Those in the eDiscovery world won't need much introduction to Terry. He's been around for 25 years in the litigation world and 15 years experience in eDiscovery. Also many years experience in the UK and other international jurisdictions. And now he is an independent eDiscovery consultant in South Africa, running an excellent blog. Check that out when you go to his LinkedIn account. Zaakir, I don't know if Zaakir has joined us as yet. Zaakir is an attorney. He is with Cliff Decker Hofmeyer and a director there. He is involved with the dispute resolution practice, a member of the corporate investigation sector, and has a wide variety of experience in white-collar crime, forensic investigation, cybercrime, fraud prevention, detection, corporate governance, money laundering, regulatory, and anything. Where we certainly have a lot of electronically sourced information. Zaakir is also an avid user of eDiscovery technology in many of these cases. And Celia, who has given us a very short bio, but please go to her LinkedIn account, is much more to be said about Celia Pinaar. Celia is with Bowman's in South Africa. She is a lawyer, and her clients are actually internal business, where she tries to improve efficiency and effectiveness in the delivery of legal services through the application of legal process design and legal technology solutions. Quite a mouthful, but please do go to her LinkedIn account. There's much more to be said. She's also a solicitor of England and Wales, she omitted to mention. So welcome to the panel. I'm going to hand over to Wasima Harrison, who will be moderating the panel discussions. and thank you for joining us. Just before we hand over, welcome to our attendees from other places in the world. I understand we have attendees from the UK, from India, there are attendees from the US. So welcome for joining us on this journey.
Thank you very, very much, Ilse. Good morning all. Happy eDiscovery Day. So just before we start our session, just a little bit of housekeeping. We absolutely want the session to be interactive. We've got our Q&A window on the right-hand side of your screen. So if you have any questions at any point in time during the session, please send us a question. If we do not get time to answer any questions during the session, we will gladly email you after the webinar. The slides themselves are available to download under handouts if you would like that. We also have a couple of our profile documents under handouts, so you could download that for ease of use. So just to kick us off, Terry, as briefly as you can, what is eDiscovery and why do we need it?
Good morning, and this is a question that you can answer in about 2 minutes or about 2 hours. I think also said there are people on this webinar today from other parts of the world and in more mature eDiscovery jurisdictions in South Africa. So for those people, please forgive us. We're in the environment here of education and awareness, as for example, the UK and the US were 15, 20 years ago. So the official definition of eDiscovery is the collection.
There's a problem with the sound.
Sorry?
There's a problem with the sound. You're barely audible and it's breaking up.
Okay. Is that better?
Much better.
Yeah. Right. Sorry about that. I was saying, so the official definition.
You'll probably have to go back to the question. That's when the sound started breaking up. Sorry about that.
Absolutely no problem. So I believe there's just a few problems with sound. Just to kick us off again, Terry is just explaining what is eDiscovery and why do we need it.
And in case you didn't hear before, I was saying that South Africa is in a position at the moment of education and awareness, much as the UK and US were 15, 20 years ago. The official definition of eDiscovery is the collection, production, and review of documents that are stored in an electronic format. And you'll note from that definition that there is no mention at all of making a reasonable search. And that's because this is evolution, not revolution. It is the types of documents that have changed, not the principles of discovery per se. Global statistics tell us at the moment that over 97% of all business documents are created electronically, and that more than 35% of those never see paper. And that's the reason that we need eDiscovery technology, because unless we're using that technology, there is a considerable and unacceptable risk that documents are being missed. So that's it in a nutshell.
Thank you so much for that, Terry, for the detailed explanation. Ishmael, if we could just move on to you, given the statistics that Terry just mentioned, about 97% created electronically and 35% never seen paper, I'm thinking in terms of evidential reliability of electronic documents. Perhaps you can comment on that.
Yes. The problems we are having in this country stems from the fact that we have a dysfunctional rules board. So our uniform rules have not kept up with what business is doing. Terry is right. I don't think anyone produces documentation commercially in some hard copy or manual form. It is all electronic. So what we require are some uniform rules dealing with the collection, preservation, and then presentation of electronic documents in court. Now there are no rules at the moment. What is happening, though, is that the judges are using practice directives to cover this. But even the practice directives are lacking in this regard. So the best way to deal with eDiscovery currently is for the attorneys to cooperate with one another. And that's not new. Discovery generally is supposed to involve cooperation between the litigating parties. It also requires the parties to be reasonable and proportionate. In other words, the abuse that we used to see with ordinary discovery must come to an end. The case managers are alive to this and will not allow extravagant e-discovery, which could end up costing a lot of money. What we are doing now, and this is rather cumbersome, is that the attorneys are required to work out what documents they need and then to make hard copies and to bring that to court. Now, in a complex matter, this could run into several files of documents. What I've seen recently in the Competition Commission as well as in the High Court is litigating parties come to a case manager and present their discovered documents in an electronic form. I've seen two forms being used, a flash drive or a CD being handed to the judge, or in one case, I've seen the attorneys come around and say, here's a website address, and this is a password. You can have access to our documents. Now, that sounds very good, except once you get into court, it is not likely that those formats can be used. So we end up going back to the old method where you'll print documents off these electronic formats and then use them in the hearing. Our courts are not paper-free yet. The Department of Justice has a policy to go paper-free, but I can't see that happening even in the next 3 or 4 years. So it's up to the attorneys to manage this and to manage it responsibly and to cooperate among themselves and with the case managing judge. I'd like some specific questions about this because I could talk all day about it. As
I'm sure you can. I'm sure you can. I promise you there's quite a few questions that's probably going to make a difference today. So fingers crossed. But thank you so much for the answer, Ishmael.
Right.
Welcome, Zaakir. I saw you have joined. Thank you so much for joining our panelists today. Just a couple of things that you've missed out. We've just introduced everyone and we've gone ahead and then just started the panelist on a quick question in respect of what is eDiscovery and why do we need it. So Zaakir, if I could maybe just have a quick chat with you. So I know that you are in dispute resolution and you also specialize in large-scale investigations, which inevitably would include large volumes of electronic documents. How does eDiscovery help you and your team?
I think from my side, and thanks for having me on the panel, Wasima. I think from our side on investigations, it helps a lot in terms of cost as well as time saving. Most of the investigations that we deal with, there's large volumes of data that we require to troll through, and traditionally lawyers are very guilty of using hard copy documents and files when working through client files and emails and that sort of thing. But the advantages of the eDiscovery platform is that it allows you to find relevant information incredibly quickly. And on the one hand, when it comes to reviewing, we can eliminate irrelevant documents relatively quickly by setting the parameters of what we need to look for. And also, if we're looking for particular hot documents, etc., it's very easy to find, especially in cases where we know what we're looking for. If I may use one particular case example of how this was compared in our firm. There was a matter that we did last year, and prior to me getting involved in the matter, the client was looking for certain relevant information, and they initially sent one of the teams a whole host of emails. I think it was about 50,000 emails, and the instruction from the client was print all of the emails, file them, and then review the information to find relevant documents. Now, I wasn't involved in the matter at the time, so what had happened is a poor candidate attorney had to print all of these emails, which came out to about 40 lever arch files. That took about 2 days. So 2 days wasted in just printing the documents, and then it took another week of late nights, etc., to look at all of the information. Then there was a second leg to this matter where there was further emails that we needed to look at. And I explained to the client that we can't do it the way that it was done before. At this point, I was now involved in the matter and I explained to them how we can use the eDiscovery platform to save on time. So we also looked at another data set. I think it was about 30,000 emails. And instead of printing it this time, we loaded it onto the platform, which was relatively quick. And we were able to start the review within a day. And instead of the review then taking 3 days, we ran keyword searches over the data set. And we identified a lot more relevant information a lot more quickly than what had been done previously. So it saved the client a lot of time. It saved a lot of money. And we were able to produce much more coherent results in a shorter period of time.
I can just imagine. I remember in the UK having done a similar exercise whereby we had two teams of lawyers, one doing it electronically and one doing it in paper. And I have to say that the individuals doing it electronically trumped it by more than a few weeks before the paper finished. So I agree with you 100%. Thank you so much, Zaakir.
Yeah, and pleasure.
No, you can continue. You can continue.
No, I was just going to say that, I mean, aside from the review side of things, once the data is loaded onto the platform, you always have access to that data. And as all investigations go, you have an initial stage where you're looking for relevant information. You find it as the matter continues. You may need to find further information, or you may also need to group information according to particular sets. For example, you may want to group it per custodian, or you may want to group the data per time period, etc. And the platform allows you to group that data very, very quickly. A lot of times, what we do when we prepare our reports, we start sifting through the information to say, okay, this is the relevant information that's going to form part of the report. So can we export that data? We then also look for all of the logs of what we did so that we can feed back to the client to say, look, we found 100 relevant emails. However, in the week that we spent doing the computer analysis, we reviewed approximately 9,900 emails because we have access to that kind of data where we can report to the client on the keyword searches that we performed, because all of that information is also stored on the platform. So it makes it a lot easier for us.
I agree 100%. And I mean, the audit trail is so important. And I think what you miss, Zaakir, is that Ishmael was just talking about evidential reliability. So the audit trail is extremely important. And I'm sure we'll cover quite a bit with regards to the audit trail. But just moving on to Celia.
Sorry, Wasima, can I just point out one thing as a follow-up to what Zaakir just says?
Yes.
What will assist in narrowing searches if one is dealing with dispute resolution, where inevitably all these searches take place, is at an early stage for an attorney to identify the dispute or the issue between the parties. Now, if an attorney doesn't really know what the scope of the issue is, and then casts a net, then searching through electronic information, and it could run into hundreds of thousands of documents, it's going to be an expensive exercise and a wasted exercise. What you want to do is at a very early stage, get clients in and put your finger on what the issue is. When you've narrowed the issue, then it becomes easier to search documents, because then your keyword searches make more sense, and they're confined to relevance. Now, relevance is key to good discovery. If a document is not relevant, you have to cast it aside. Just because something is interesting is of no use to a judge in a hearing. So relevance is applied very strictly in our courts. Even before we go into proof of the document, we'll first deal with the relevance. So my advice involved in dispute resolution is, before you start electronic searches, first satisfy yourself as to the scope of the dispute.
Yeah, and I mean, nowadays we're working, I think the big word at the moment is volumes, and I mean that is the main issue at the moment, because data sizes has grown exponentially over the last few years.
Correct.
So clearly technology will filter out large data sets, but the results will still have to be reviewed. So if I can maybe just point this question at Celia. And Celia, in terms of your project legal management and legal project outsourcing experience, how would you apply this to assist with large volume projects?
I think to think back to the years where we used to manage projects for some of the UK law firms, you know, the Prince & Masons and the Eversheds and the really big players, we were looking at more than 500,000 documents that have already been filtered and that required a first level review. And with first level review, we're referring to the team being briefed on what the key issues of a particular matter are, and then reviewing documents for relevance, perhaps certain categories, and also potential privileged documents. And the technology allowed us, first of all, to actually work in South Africa, delivering to teams in, for example, in England, obviously offering them a significant cost benefit. But it allowed us to build in a certain workflow into the tool so that you can actually assign pockets of documents to particular users. You can bulk exclude certain documents that you learn might not be relevant down the line. You can perform quality checks, which I think compared to the manual process is a significant advantage. All of a sudden, your entire team could access documents real time. It's no longer a case of passing on a lever arch file to someone or making sure that an exact replica is with someone else or quality check. It allowed us to automatically do certain bundling functions and create chronologies. And also it created an audit trail for every single document to show what decision was taken on that document, when, and by which reviewer, which gives you a lot of information which you wouldn't necessarily have had with the paper documents. I think applying that to the South African market and what we've seen in the last 4 years, I think first of all, the volumes are much lower. And initially when we tried to introduce the concept of eDiscovery platforms to some of the law firms I've worked at, you know, the first question is always, but you know, I only deal with 2,000 documents, why would this platform be useful? And I think if you think of the benefits that I just mentioned about the outsourced model, a lot of it still applies, even if the volumes are actually quite low compared to some of our global law firms. The benefit is that it's available immediately. As Zaakir mentioned, you know, in a couple of days, a couple of hours, you can actually start your review process. The quality is much better because you know which documents are there. You can copy it to a folder for someone to review. And you've got that audit cloud to continuously see what decisions are being taken across the documents.
Wow. Thank you so much. I mean, a lot of points that you just mentioned are extremely helpful and agreed with 100%, I'm sure. So just moving on to the next topic. Both Terry and I have worked in the UK for many years, and we saw the roles of judges develop to the point that they were managing cases. And the importance of case management conferences in the UK and or meet and confirmed as in the USA, they developed enormously. So my question is, should the South Africa judiciary play a bigger role in eDiscovery? And Ishmael, I think you might be in a good position to start us off on this one.
Yes, certainly the judiciary, well, currently the judiciary plays the most important role because judges, as you know, are not confined to the uniform rules. They can regulate their own procedures, and that's exactly what they're doing. They are producing what are called practice directives, which are published from time to time, where they will deal with the question of eDiscovery. There are none at the moment. I don't think they've applied their minds to it, and that's because we have an unfortunate situation in this country where most of the commercial dispute resolution is gone into arbitration, and it stays out of our courts, with the result that the common law is not being developed with regard to proving electronic documents. But I think that will develop. They started a commercial court in Pretoria. It's not a new invention. We had one years back to try and get business back into our courts. I can tell you business is staying away from our courts, and we don't have to go into why, but that is creating a problem. So the judges don't have enough of an opportunity to deal with this and contribute either through directives or through judgments. If they had the opportunity, I think you'll see much more coming out. But business currently is going to arbitration. And I know there are some really good judgments coming out of arbitration where experienced lawyers are writing about electronic discovery and the evidential value and the weight to be given to electronic discovery. The combination of poor rules board performance, no commercial work in the high court is holding us back.
Oh, thank you so much for that, Ishmael. Terry, do you by any chance have anything to add to this?
Well, I think Ishmael's obviously is 100% correct. I mean, what we need is we need more cases, clearly. We need judges to understand eDiscovery better. Don't be hard on yourself, South Africa. All these other countries have been through this. And, you know, I can remember years ago in the UK judges didn't want, some UK judges were very concerned about technology, didn't understand it. We do need our judges to be more knowledgeable. I remember being at a seminar in London a few years ago when one of the main speakers, who was a very highly respected judge, said to the audience, consisting mostly of lawyers, that if they did not know the key dates in their case, if they did not know the key custodians in their case, and if they did not know the key words in their case, then they were negligent. Might sound a bit harsh, but he has a point. And, you know, other judges, once eDiscovery really took hold in the UK, other judges regarded themselves more as business managers, running the cases, and I personally think that's excellent. What it needs, obviously, is, as Ishmael says, we need to change the rules. We know that. We're working very hard on that here. And the judges would require some training. And by the way, so that everyone knows, Ishmael and I are prepared to train South African judges in eDiscovery.
Yeah.
Now, please go ahead, Ishmael.
If you look at what's developed in the UK and in Canada, the USA, in those jurisdictions, the volumes of electronic data is enormous. So the way the attorneys manage it is they use the technology. They also outsource some of the work to try and compact the volume of the documents, and then when the attorneys get hold of the documents, they will have more or less what they require for their dispute. So the relevant documents will be presented to them. The problem, the way they dealt with it in the UK and in Canada, especially in Canada, they use case conferencing between the case manager and the two sets of lawyers, and they reach agreement on as much as they can, so that when the matter goes to court, you're not bogged down with thousands and thousands of electronic documents. And what the good case managers do is that they insist that eDiscovery must be proportionate to the dispute. In other words, let's look at the issue and confine ourselves to documents that are relevant to that issue. Then they agree on matters of admissibility. What they do is try and avoid the situation where they have to look at metadata, for instance, or to look at inaccessible data, such as fragmented data or erased data, so that the cost of reconstructing data is eliminated. So as far as judges are concerned, one of the issues that they're very sensitive about is costs. How much court time are you using in proving documents? What we encourage parties to do is to reach agreement. Now, that's not new. We've always done it that way, but it still didn't prevent parties coming to court with 20 lever arch files. I can tell you, having spent years on the bench, I very often got between 10 and 15 lever arch files handed up, 3-day trial, and the attorneys used 3 pages of that. Now, that's an abuse, and it can be much worse with electronic discovery. So the answer is for cooperation to take place between the judge and the two parties. Now, what we are heading towards is that all of this will become part of the certification process in our courts. We no longer allow attorneys to set down matters without a certification from a judge that they are trial ready. Now, trial readiness will include eDiscovery and agreement on the admissibility of documents. It's only where there is a dispute that can't be resolved, or maybe the document is the issue, then that goes to trial. Otherwise, it's all going to be done by agreement and cooperation. Okay.
Okay, thank you so much for that, Ishmael. Zaakir, can I just ask you, would you like to see South African judges taking a more critical role rather than simply just asking parties at what stage in the case they are?
Yeah, I think at the end of the day, if everybody plays an active role, I think it would just make things so much easier. And I think judges are in a position where they can really set the trend to get also the lawyers on board in making sure that when we deal with cases, we deal with them efficiently. Because a lot of times when you're dealing with volumes of data, it's just the nature of the way we're communicating nowadays. Email communication is the primary means by which most people communicate in their businesses. So obviously, by that very nature, the volume of data that you're going to look at when there's a dispute or when there's an investigation is huge. And often, like Ismail said, not all of that information is necessarily relevant. And I think if judges become much more strict in making sure that parties pay more attention to what it is that they're putting forward before the courts, that might go a long way in making sure that we also curtail the volume of information that people need to traipse through, because our courts are already overburdened by dealing with so many matters that we want to try and lessen that burden. And the only way we can do that is having our cases dealt with effectively. And I think all parties have a role to play. You've got the attorneys on the one hand, and then you've got the judges on the one hand who can set the tone and really hold attorneys to task if they come to court with, wads of irrelevant data, just to scare the other side by saying, look, I've got 20 lever arch files of information, etc. I think it's unnecessary, it's inefficient, and I think we should work towards actually dealing with the issue at hand.
Thank you so much for you, Zaakir. So Celia, just going back to your earlier comments about project management and review, etc. Would you like to see the judges in South Africa being more concerned about proportionality? Celia? Okay. Yeah, she's back online.
Okay. Okay.
There we go. Can you hear me now?
Yes, we can.
So just taking it back to the UK days again, where, as was already mentioned, the courts really highlighted the reasonableness and proportionality factors. I think definitely there's a long way to go in our legal system to focus on that. I think there's a lot of uncertainty in terms of what is allowed. Are you allowed to outsource the review to an external party? What happens to privilege? A couple of things that I think firms are just really struggling with and trying to make headway in, but it would be great if there's some sort of formality around the approach and the decisions to be taken. And Terry, you might have seen some of the results that came through over the last few years following the introduction of the case management conference concepts in the UK. I think there's definitely great value in having the court support and even perhaps law societies to an extent, just to promote the availability of these types of systems and processes to support the eDiscovery process.
Yeah, absolutely, Celia. And I think it's interesting that, the way that, for example, as you rightly mentioned in the UK, the way that new rules or practice corrections are declared is quite different than here in South Africa. I mean, the UK next month are just about to embark on what I think will be their third review or revision of eDiscovery rules, and we haven't even had our first one yet. But what I think is particularly relevant is that they form an external committee to work hard on preparing new rules or amendments. That committee always consists of at least one judge, if not more. And indeed, the most recent revision, which is going to take place, as I say, on the 1st of January, the committee was headed by a very senior judge who play this, as you so rightly say, important role. And I think, as everyone said, proportionality is the overriding objective in the UK now, and that's spreading over into the States. But UK-led proportionality, I think hopefully we would take that up too. The second very important point, and the new rules in UK from January, is something that Ishmael mentioned earlier, and that is collaboration. The two overriding objectives will be collaboration and proportionality.
Can I add one more interesting development here? Is that in the past, attorneys got away with extravagant discovery. But the recent trend now is that if you come with more documents than you need, and and your discovery is out of proportion to the issue that's being dealt with, the judges are now disallowing the costs of the discovery and even making adverse cost orders against the attorney. And attorneys have to be alive to that. And that is the trend, not only in this country, but it's been happening in the UK and in Canada and in India and Australia for some years now. Okay. There's nothing like costs to be a deterrent, I can tell you.
No, I can just imagine, because it moves very nicely into my next question, So just following on from that, Ishmael, if I could just move on to my next question, and that is basically, how does eDiscovery technology reduce the cost of litigation and investigation cases. If I could maybe just take this to Zaakir. Your clients want to know about cost from the outset, I'm sure. How do you
Yes.
deal with the fact that you will be using technology in their cases?
So that's a very good question, because I face that question in every single one of my investigations. And how I've learned to deal with it is always at the outset, having worked on the platform, I've also developed or I've also learned how to use the program smartly. And so what I always do is I understand, for me, what is critical is understanding what we're trying to achieve in the particular matter. What is the nature of the matter? Then the second leg for me is to understand more or less what is the period of the data that we're going to be looking at, so that I can understand the size of the data. And then upfront, I'll discuss the costs involved with the client. And initially, their eyes might go big to say, well, if you're using this platform, there's going to be this disbursement cost on your invoice. There's going to be a hosting cost, etc. Isn't it going to be expensive? And my answer to that is very simple, that if we don't use the platform, then the costs are going to escalate, because then you're going to have lawyers, be they candidate attorneys or associates in any law firm, printing out documents, then having to sort the documents manually into some sort of chronological order, trying to make sense of the emails, etc., that they've received. That process is going to take about a week, while we try to get the documents into a form that's ready for us to start reviewing. And then once you review the documents in hard copy and you flag them, etc., and if somebody else wants to review it, or if somebody else wants to review a particular set, it's just going to take longer for them to do it, because you're not working through a platform where you can easily search for what you're looking for. And then I explain to clients the benefits of using the platform, and I think we've canvassed it in our discussion this morning. And those would be, for example, once we use the platform, yes, there's an initial disbursement cost and there's a hosting cost. However, you're saving on the lawyer's fees. Dealing with unnecessary admin relating to the information that you're looking at. So you're actually spending your money on the lawyers doing meaningful work through the data set, by setting parameters of the information that you're looking at, by not duplicating any work. Because one of the other things that I think we must mention is that the program deduplicates any duplicates. So you're not going to find yourself reviewing the same email twice. And even if I have my team looking at data, etc., when they're flagging the data, as they go through the data and they mark something as irrelevant, that mark stays there. We can see what we've reviewed, so we don't have to review the same thing twice. So once we flag something as relevant, it will be relevant, and we don't have to read the same email twice. And then we can start searching through the data smartly. Because the other thing is, as we work through the data, we also start to understand what it is that we're looking at, so we can then hone in on our keyword searches. And so whilst we may have a preliminary list of keywords to identify some data, as we learn the users or the particular email profiles of the people that we're looking at, we start performing more focused keyword searches to find much more relevant information. So there's a whole lot of cost saving that goes on in there. And then I also explain to clients that once we've identified all of the relevant information, to export that data is going to be quick, as opposed to us working through hard copy documents, etc., and wasting costs. So in the long run, you're going to save astronomically on the legal fees. So yes, don't be penny wise and pound foolish. Rather spend the money on the platform, and then you're going to save in the long run as you work through the data. And then the second thing is, whilst we've spoken about large data sets and how it's very valuable for large data sets, and that we all know, but I've also used it in matters where the data set is relatively small. And the reason why we do that is because it still saves us on time, and it still saves on legal fees. And I've actually seen it in practice where we were dealing with relatively small data sets. But the advantage is, once you understand how the program works and how the costing of the program works, you can actually use it for small data sets as well.
No, definitely. I mean, over the years, I've used technology on all types of cases, whether it's small or big. There's so many different tools out there that would be able to achieve the same thing. So 100% with you. And while I might just add that I love that statement, and I think it should be our new slogan.
Azima, if I can perhaps just If I can perhaps just add something on the costing and the pricing front, I think it's also worth pointing out that because costs are usually incurred on a matter-by-matter basis, based on the volume that you deal with, these types of platforms and technology would also be available to some of the smaller firms. I know that's a concern that we often face at conferences and the like is, how do smaller firms get access to this? And the reality is that all of a sudden they don't need teams and teams of paralegals or CAs to help them sift through the documents in case preparation, because the pricing would be similar to the firms regardless of size.
Right.
Yeah.
Well, yeah, actually a very good point. I'm a champion. I was in the UK and I'm the same here in South Africa. I'm a champion of the smaller firm. And no disrespect to the big firms, but I want a level playing field. And I believe that technology, eDiscovery technology does actually level the playing field and allows the smaller guy to compete with the Goliath. I don't want cases whereby the big firms turn up at trial with their laptops while the small guy turns up with 20 boxes of paper. There's not the slightest doubt in my mind that eDiscovery technology levels that playing field and actually supports and underpins the smaller guy, the bigger guy. Global statistics tell us that
Terry,
the largest cost,
your sound's getting worse again.
The largest cost of a litigation case is review, and that amounts to something like 70% of the total. Another statistic globally is that eDiscovery technology will reduce the costs by approximately 35%. That's a lot of money. And if, coming back to Zaakir's points, if you've got a case that you tell your client's going to cost 3 million, but you can save 3 million rand, you can save him 1 million rand by using technology, you've got a very happy client. On the other hand, if as a lawyer you decide you don't want to tell him because you don't want to lose that 1 million rand, that's fine, but soon you'll have no clients.
Yeah.
Yeah.
Sorry, Terry, just to add one comment about what you said about cost. One of the most serious abuses involving the David and Goliath type battles with big firm, small firm, is what we all know as document bombing, where the big firm overwhelms the smaller one with so much documents that they just don't have the resources to review them and to work through them. Now, eDiscovery, coupled with good case management, eliminates that completely and thereby reduces the cost.
Agree entirely.
Yeah, if I can just add one point that I thought about is just on the efficiency and the cost saving side. I mean, we had a matter once where it was a dispute that we were dealing with an arbitration, and during one of our discussions with the opposing side, two things had come up. They had mentioned something that we were not aware of initially, and that immediately prompted us to have to search for a particular document, and we knew exactly what we were looking for. Now, because we had all of the data loaded onto the platform, it was easy enough for me to just get one of my team members to immediately go search for the document. So we were able to find the document in the space of 10 minutes because we knew what we were looking for. And then the second thing is they asked for a whole host of information. And in that information request, they told us what the parameters were and what the user profiles were. And in the normal course, had we done it on the hard copy based system, if you were sitting with Lever Ash files, we'd have to traipse through to find all of the information, etc. However, that morning we were immediately able to set the parameters and export all of the data that was required. And before the close of business that day, we were able to give them the information that we wanted, so there was no delay in the case. We were able to deal with the issues quite effectively, and I think that saving of time saved the client a lot of money as well, because it saved us on a day or two of having to work through hard copy documents to find what the other side was looking for.
No, definitely, definitely. Thank you so much for everyone on that particular question. I notice we've got 10 minutes left, so I'm just going to rush us along a little bit just so that we can get through one more question. So just thinking about the future and where attorneys are heading, should attorneys be more aware of the impact of technology and alternative legal services with regards to the future of the profession? Ishmael, I know that you run
Yeah.
seminars and on a regular lectures. How techy savvy do you think SA lawyers are? And is there a thirst for more knowledge?
Well, can I tell, last week, I'll give you an example and you can draw your own conclusions. Last week, I presented a writing course to 48 attorneys. It was here at Midrand. Somewhere along the way, I had to talk about metadata. So I said, put up your hands. How many of you know what metadata is? And out of the 48, not one hand went up. And this was not really relevant to the course, but I ended up spending 15 minutes explaining what metadata is, and that was the first time they heard about it. That's the attorneys in this country have been very comfortable because the profession was regulated, and much of the work was that attorneys did only they could do. But the profession is now under severe threat by disruptive technologies, but also legal services are now being deregulated. So they're competing with the internet, they're competing with banks and insurance companies. Their biggest competitor are the big accounting firms. So if the attorneys don't embrace technology, not only in the way they service clients, but the way they manage their practices to start with, they will not be able to sustain practices for very long. Now, I know there are a number of all the big firms. If you take the big five here in the country, they have embraced technology. One of the firms has even introduced artificial intelligence here in Sandton. Artificial intelligence is being introduced in law firms in the US and the UK. I was pleasantly surprised to see it being introduced here in this country. But that's on one end of the scale. The other end of the scale are attorneys who are practicing with no technology. Okay, their idea of advanced technology is the fax machine. So
Yeah.
So we have a long way to go in this country, but the awareness is creeping in. And ultimately, if they don't transform their practices and then keep reinventing it as the years go by, they won't have a sustainable practice.
Yeah, I think it's being scared for change, you know. And I initially came over to the country 4 years ago, thinking we were probably about 2 years behind the UK. And every year that passes, it just adds up. So it's quite a scary point. But I mean, it just brings out that training is definitely needed, but probably also the mentality that change is here, and it's something that needs to happen.
Yeah.
Thanks so much for that, Ishmael. So, I mean, talking about change, I mean, Celia, the fact that South African law firms employ people with your skills and experience, is that an indication that they are aware that change needs to happen?
I think, Wazima, to be honest, the likes of me actually scare some of the firms, to be honest. I think some of them might approach it to think, let us rather have this person in-house than have him or her work with our competitor. But I think there's definitely a move towards finding out what non-traditional skills are available. And the approach that I've taken since rejoining the law firm after being in an outsourcing environment for so long is that you need to start educating across all levels, and it could take very different forms. So, starting at the bottom, your secretaries need to be included in these types of discussions about legal technology, what it could do, why would lawyers need it, how do you work with these types of systems. Your juniors definitely need to be included. What we did quite successfully at Webwenzel was to introduce demo days to show them, Ishmael, to come back to your comment, we were the first to implement AI. And you need to show people what it is, what it does, how it works, how it could benefit them. You need to train them on the system so that they can start working with it themselves and not feel that it's something, exclusively for some of the larger matters. Then you also need to accept that there are some of the older practitioners who might not be familiar with these platforms and who might not be interested. You sort of choose your battles and decide where it's really worth investing your time in, but also going back to them with case studies to show, this is the benefit it is added on a specific matter. This was the cost saving to the client. This was the benefit to your team who, managed to focus on the higher level work because the lower level time intensive work was taken away from them. And you also, I think, need to focus on the external community, your council, your VAC student workers, getting everyone involved in the thinking around what it could mean for them. So it's not about introducing a general, legal tech course or anything of the like. I think it's just getting people to understand that there's benefits in it. And perhaps also placing the burden on them to upskill themselves and not to expect it always to come, from the top and for someone to equip them. A lot of this is there's some personal interest and appetite to embrace what we think is coming.
Yeah, I think all we can do, and I'm sure everybody agrees, is just wish you luck in your role.
But the point to be made, to follow up, is that business has embraced technology, because without it, they're not going to make money, and the competition would leave them behind. So business has progressed at a far greater rate than the profession and the judiciary. Professional judiciary is constantly going to play catch up, and the sooner they embrace the technology, the better.
I agree entirely, and I always say that the way that I've seen, for example, eDiscovery technology advance over the last 10, 15 years, that has been driven not by software suppliers, not by attorneys. It's been driven by what I call globalcorporation.com. Because it's these corporations who've said to their attorneys, I'm not going to pay you to look at irrelevant documents. I'm not going to pay you to print blank pieces of paper. I only want to pay you to do what you're good at. And so they have driven all these technological changes. It would be fantastic for South Africa if we had, we've got one or two global corporations who are good at this, and it's best if I don't mention names, but it would be even better if there were more corporations, institutions who actually were driving this, and they would promote the change within the attorneys.
Can I sort of end this discussion with another incident that took place that will demonstrate where we currently are? Now we're talking about the profession in Sandton. Let me move you to the heart of our commercial of the commercial activity in our country, Bloemfontein. Okay, I was in Bloemfontein, and an attorney came to me and said he's got a serious problem. He had to issue a summons on behalf of his client to collect on a goods sold and delivered transaction. So it's simple stuff. He issued it out of the magistrate's court. The defendant didn't enter appearance to defend, and so he applied for judgment by default. Now, the document that he had to hand in with his application was the invoice. Now, the invoice was produced on a computer, and they merely printed a copy of the hard drive. This goes to the magistrate. The magistrate rejects the application and demands that he gets the original invoice. So now the question was, what is an original invoice? Now, I realized if we had to now explain metadata and audit trails and so on to a magistrate, it's not going to work. So I came up with it that worked. The answer was simple. I said to the attorney, go to a stationery store, buy a rubber stamp that says original, and take the same invoice, stamp it, and send it to the magistrate. You got judgment. Okay.
Wow.
That's where we are.
Evidential reliability.
Yeah, the good old rubber stamp still works. That's it.
No, I can just imagine. But I mean, thank you so much. I think we've probably got about 1 minute to wrap up. So we've definitely run out of time. This is such an interesting topic, and I'm sure that we can keep going a whole day. So just to wrap up, can I perhaps just ask each one of you just for a one sentence message or point that we can leave with our attendees? Ishmael, perhaps you could go first.
Yeah. Oh, simple, adapt or die.
Love that. Celia?
Sure. I think from my side, it would be, I think we often assume that, firms want to continue on their own and not share any knowledge, in the fear that they might give away some competitive advantages. But I think there's definitely value in collaborating with some of the other firms and some of the other players in the field to share ideas, just discuss a couple of potential concerns. We've done it over the last few years, I think, to some extent successfully, but I do think there's definitely interest in platforms to start having more of these discussions.
Perfect, thank you. Zaakir?
I think from my side, I think our clients expect the best from us, and for me that doesn't mean just being the best at the law. I think we need to embrace technology so that we can provide the best legal services to our clients, so that we can be more efficient and effective in representing them and assisting them with the legal services that they require.
Thank you so much, Zaakir.
Well, my simple message to South Africa is don't wait for the rules to change. eDiscovery is here right now.
Thank you so much, Jerry. I think at the end of this, we probably have so much slogans that we can definitely pass around. So just before handing back to Ilse, let me just say that it's clear that whilst we do not have rules of eDiscovery in South Africa, which puts us behind other jurisdictions, we do have people here in South Africa who are certified in eDiscovery technology, and we have a large number of lawyers already using it. So there's definitely hope for South Africa. So thank you so much from me as a panelist, and handing it back to Ilse.
Thank you very much to each and every one of you for giving up your time to participate in this panel. The webinar has been recorded. So those that couldn't make it this morning, we realized that it was an early start, will receive the link to listen to the audio in any event. I'd like to thank Wasima for putting together the panel, the slides, and all the preparation that went into today's webinar, and also Lextrado and Seanre for sponsoring the event for us. And then you will see in the middle there, there's also a reference to the Association of Certified eDiscovery Specialists. Please visit their website. The eDiscovery process that we follow, even without the rules, is basically international best practice. We are working with larger and larger volumes of cases. Many of our cases currently are running into the terabytes of data, and the judiciary, the legal fraternity in general, actually, is coming alive to it. We're dealing with a number of cases where we already have judges taking up the role of case managers when it comes to large data sets. So we're quite excited about that. But yes, thank you for the insights and the very important aspects of early case assessment, early data assessment, the importance of chain of custody when it comes to electronically sourced information, and also the real examples given by Zaakir on the use of technology. So yes, this is the first of many webinars to come, and have a lovely day further.
Thank you so much, Ilse, and just wishing everyone once again, happy eDiscovery Day. Thank you so much, everyone, and have a blessed day.
Thank you.
Thank you.